why can I do this? And I said, because you want to. And he said, it's called reasonable suspicion. So at a border, they don't have to have any cause at all, okay? Drug tests are questionable. Technically, you cannot be forced to give your blood, your urine. Wiretapping has been a big issue, especially because of the war on terror, and we will hopefully get to that at the end, okay? All right. So the Fifth Amendment prevents self-incrimination and double jeopardy. Also, it says with eminent domain that the government, if they want to take your property, have to pay for it, okay? But it prevents self-incrimination and double jeopardy, which means this. Miranda versus Arizona. You guys ready? You can turn on your mics and do it with me. You have the right to
remain silent.
Anything.
Minecraft.
Anything you say can
be used against
you.
and will be used against you
in a court of law.
You have the right to
remain
attorney.
silent.
An attorney. And if you cannot afford an attorney,
one will be appointed for you.
One will be appointed for you. Okay. So one of those things too that you should know about when we're talking about these rights, these are hard won, and they're not necessarily hard won by people who are wonderful people. Okay. Miranda was kind of a creep. Okay. But because of this fight, because of this, right, we know that, and we the people can say that, hey, look, you have to inform me of these things. You have to tell me. You have to remind me, because, hey, getting arrested is traumatizing. And so you don't remember things. And when people are trying to be nice to you and saying, yeah, you know, hey, look, we're on your side. Don't you want to do the right thing? Then you say, yeah, I want to cooperate. The answer is no, shut up. And I'm serious about this too. Never consent to a search and shut up. Just shut up. You have 2 words that you can say. My lawyer. Call my lawyer. There, 3 words. Call my lawyer. I want my lawyer. These are the words you can say. Lawyer, lawyer, lawyer. If you're arrested, shut up. And I don't care if you didn't do it. I hope you didn't do it. The exclusionary rule comes from both the Fourth Amendment and the Fifth Amendment. It bars the use of illegally seized evidence at trial. So this is established largely in Mapp versus Ohio. They're searching for a fugitive, and they find porn in a box. And so the Supreme Court says, here's the deal. You were searching for a fugitive, fine. You're on a hot trot, whatever, and you're trying to find that fugitive. We can see why you might go in there in that case. But a fugitive is not going to be in a box that's this big, right? So you can't search that. And so that is kind of the first where they said, we're going to start excluding anything that you do. In 1961, right? These amendments have been around for a while. In 1961, the court says you can't do that. There's a growing number of good faith exceptions in the last 20 years. In 2008, Herring versus US establishes that there can be an honest mistake by the police officer, in which case they can still use the evidence. In this particular case, it was an outdated warrant. They had the wrong address, the wrong name, and they killed someone who was an innocent. Okay. So when we talk about this, when we talk about honest mistake, we're concerned about the fact that there are 2 kinds of honest mistake. One is on the part of the police, right? And this is pretty egregious, right? And it's been rolled back a little bit, some of the Scalia opinions. But at the same time, when we talk about what it means to follow the law and make sure that enforcement of the law is done constitutionally, right? Then we're talking about a requirement that we adhere to those principles, that the government has a responsibility to adhere to these rights and limitations. The Sixth Amendment is going to protect your right to counsel and jury trial in criminal cases, okay? Gideon versus Wainwright is going to set the precedent for counsel, and the court has ruled unanimously a number of times that a lawyer is a necessity in criminal court, not a luxury. State must provide a lawyer to poor defendants in any case that involves incarceration. Trial must be speedy, and it must be a peers, which is a whole other issue because jury selection has been historically not something that has been of peers, right? First of all, ethnic minorities and women have been excluded pretty regularly. And even now, when we talk about who sits on juries, it tends to be people who are older, whiter, usually more retired than anything else. That's not entirely true. There are other ways other people get on juries. I was called to jury trial once whenever I was 19, but I was in college, and so I was excused. And then I went to law school. And after one semester of law school, you're never allowed to sit on a jury again. You're never allowed because you know too much about the law. Because you know too much, you're often excluded from juries. If you know things about the law, you're usually kept away from trial, which is a little worrisome. The Eighth Amendment protects against cruel and unusual punishment. It has to be and, both cruel and unusual, not just cruel. The death penalty, it's unconstitutional for a period in the 1970s. Basically, Furman versus Georgia, you really need to know that case as well. Furman versus Georgia determined that in Georgia, if you were Black and you were tried for murder, the prosecutors sought the death penalty more often, or frankly, they sought the death penalty, and if you're white, they sought life in prison. And so everything was done so that it became bifurcated. If a prosecutor wanted to seek the death penalty, then they would plead their case and try to get someone convicted in a jury, right? And then there has to be a separate jury that hears both mitigating and aggravating circumstances to determine whether it should be a life in prison or a death penalty case. Even though there have been many cases since then that have clearly shown statistically that if you are Black, there continues to be a systematic bias against the likelihood of receiving the death penalty, the Supreme Court has said that is not enough to call it unconstitutional. Minors and the mentally disabled are excluded from the death penalty for the most part, okay? If you're 16 or 17 in Oklahoma, you can still get the death penalty. It depends on the state. If you're 15, you can't. And I want you guys to think about this. I don't know why I have scissors. I want you guys to think about this, okay? What we know about human psychology is essentially this. In terms of impulse control, full brain formation does not occur until people are 25 years old. 25. And we're willing to convict and sentence to death someone who's 16. So there's a growth of innocence projects and with using DNA evidence from past cases of people who are on death row, finding more and more people who have been convicted based upon the bias of whether it's the police, the enforcement, the prosecutors trying to get a conviction, all of those things. Bays versus Rees is going to uphold the constitutionality of lethal injection even when there are chemicals missing. In Oklahoma, you can no longer get one of the chemicals. It's no longer made actually anywhere in the world. And so they use 2 out of 3 of the cocktails, and the Supreme Court said that's okay. Which is interesting because torture is something that has been long considered to be something that is unconstitutional by the Eighth Amendment, force feeding, waterboarding, but A lot of that is a concern when we talk about these missing chemicals, because the chemical that was there was meant to deaden the sensation of the death penalty, and it's considered to be torturous. So the killers, we're talking about how we have more people in jail than anybody else. Okay. This is from 2013. The proportions have not changed. The proportions have not changed. The United States has more people in prison per 100,000 people than any other place in the world. By a lot. By a lot. The number of people in prisons and jails for drug offenses, a lot of this is connected, right, with the war on drugs that starts in the 1980s. In 1980, there's about 41,000 total drug offenders in prison. In 2011, there's 501,000 drug offenders. At the same time, public perception of crime rate has not gone down. People continue to believe that there is more crime in the US than there was a year ago. Oh, it's worse than last year. It's worse than last year. It's worse than last year. I mean, there's a decrease that we see in the 90s, right? But then it goes back up and it's still at around 68. But what's happening is that crime is actually decreasing and has been. It is a quarter of what it was in 1993. A quarter of what it was. But the media and also politicians running on this idea of rampant crime continue to make people believe that there are high levels of crime in the United States. So how did mass incarceration even happen? Well, we declared that the war on drugs, we declared a war on drugs just as inner cities were collapsing. Their economies, lots of factories were moving out during the 1980s. There was a lot of globalization going on, and inner city economies collapsed. And so people were trying to make money and they were selling drugs and doing drugs, and we declared a war on it. Both Democrats and Republicans competed to be tougher on crime. And mandatory sentences, no parole, no judicial flexibility were part of federal sentencing guidelines that were then adopted by states. So that meant that if a 19-year-old came in front of a judge and, was caught with a whole bunch of weed, the judge didn't have a choice but to put him in jail for 10 years. There was no leniency. Finally, private prisons. They're a big business and they give a lot of money to give lots of campaign donations, give a lot of money to politicians running for office, in particular at the state level, okay? Because people don't pay as much attention to who gets money from where among state legislatures. I'm going to take attendance really quickly. And I'm going to remind you that when we talk about private prisons, Oklahoma has 5 private prisons in Oklahoma. And the idea was they would bring economic benefit to the state. Private prisons will only take in non-violent offenders. And so these mandatory minimums for drug offenses are something that is perfect for them. And they lobby to create these laws. Again, attendance is live. You got a minute and a half left. Michelle Alexander wrote a book called The New Jim Crow. And one of the things she points out statistically is that drug use and criminal activity is equal across ethnicities. You're not any more likely to commit a crime because you're pink, or because you're white, or because you're olive, or because you're brown, or because you're black, or because you're anything, okay? Drug use and criminal activity is equal across ethnicities, but the sentencing disparities target particular groups, both systemically, right? So for example, with crack cocaine, you got a much longer sentence than you did with powder cocaine in these mandatory minimums. 10 times as long.
Why? Sorry.
They wrote the law. And actually, there's been some discussion that this was a mistake when they were doing the massive crime bill in the 1990s. I've read that, but it doesn't matter. They didn't change it. So these are primarily nonviolent and small-time drug offenders that are incarcerated. And the poorer you are, the more likely you are to go to jail, because you have a public defender who's overwhelmed and they say, hey, let's just plea this out. But once you plea bargain, you now have a felony. And the next time you go, you also have another felony. And the third strike means what? You go to jail for life in many states. The poor are often manipulated into choosing that. It also disenfranchises people. Ex-felons are going to lose the right to vote, some for life, some just while they're on probation. In Florida, there were 600,000 people who had done their time and could never vote again. So the Floridians directly voted to change this in 2018. They had a ballot measure, but the legislature, when it met, immediately rolled it back, saying that it was a felony if you voted and you were an ex-felon and you had any outstanding court fines anywhere. And there's no database where you can find that. There's no database where you can find that. Oklahomans also directly voted to reduce many felonies to misdemeanors 3 years ago. And so it took 2 full years for the legislature to enact. As a result, Oklahoma actually no longer has the highest rate of incarceration because so many people were let out because of that. Their sentences were commuted. But there's also legalized discrimination, and this is important. These low-level felonies mean that you can never hold most jobs again. Alexander says, in major cities, almost 80% of young African-American men have criminal records and are subject to legalized discrimination for the rest of their lives. For the rest of their lives. So when you're thinking about, hey, well, you get out of prison, you're going to make a better life for yourself. Are you? Can you? Is it possible? It's hard. The Black Lives Matter movement is going to rise out of this context. The people have been so disenfranchised, so discriminated against, that they are unable to get back up on their feet. John Carl is an OU sociology professor. He wrote this book with Mary Luman, A Country Called Prison, and he said, you know, you're right, race is a big deal, but it's not the whole picture. The main problem is this: it's not our crime rate. We don't commit more crimes in the United States than anywhere else. We incarcerate people for crime more than anywhere in the US, in the world, sorry. We tend to criminalize those who frighten us. Yesterday, I was reading a story that a man died in custody just yesterday because the police leaned on his neck with a knee for more than 5 minutes. We've heard this story before, right? We had riots all last summer because of it, or in protests, right? But they were responding to a mental health emergency. We criminalize those who frighten us. He was not breaking any laws. He was having a mental breakdown because we don't know how to deal with it. One of the big issues when we talk about the police is that the police are not trained to do this. That's not what they're trained to do. And with Homeland Security and the way that we've been funding local police forces to become SWAT teams, they want to use that fancy equipment, right? You guys were talking about buying a tank. Hey, join the police, right? They got tanks. And here's the key. They're trained to do a certain thing. They're trained to react a certain way. And so whenever communities start talking about things like defunding the police, right? Like Norman did, let's use the Norman example. Norman said, what we're going to do is instead of increasing the number of police officers we have, we're going to take that money that we had set aside for that, and we are going to instead create mental health squads, people who can go out and respond to these sorts of emergencies. John Carl points out that we have a real mindset in America, and it's difficult to get out of the way that we view crime and otherness, right? Some of you apparently are taking Dr. Carl's class right now, which is fantastic. He talks about tools to break the cycle of prison, okay? Obviously education, literacy, but also training, right? Training, and not everything, you know, there's an old saying, when all you've got is a hammer, then it seems like the perfect job for everything, right? Sometimes a screwdriver is better. Mental health teams do make a difference. Okay. So I have a poll for you. And my poll is somewhere. And I can only list 4. There are 6. I understand that I'm leaving out, but these are the 4 that we've talked about over the last 2 days. And so that's why I put them in here. All right, it's active. I'm going to talk about privacy while you guys are answering this. Like I said, actually, we have 15 minutes. I've been flying through. It's possible that I did not pay attention to the chat. I know you guys were talking about important stuff and uncomfortable stuff, and I think that's all.
We muted it for a little bit because it was getting a little out of hand. So,
well, so the chat I know was kind of live wired today, and so I had to go on with what I was doing, in part because we have so much to do. I haven't. If you did miss attendance, I think Erica's already fixed it.
I've already fixed them.
And so there is one person who says that he missed. All right. But let's talk about the right to privacy. I'm doing the poll right now. It looks like 163 of you have plugged in so far. There's still over a minute left. So go ahead, and if you need to restart your phone, you can do that, or not restart your phone, but restart the app. All right, let's talk about the right to privacy. The Supreme Court, over a period of time, and this begins in the 1800s with Yoder, okay, start talking about things like the right of people to determine their own child's education and their religious upbringing. Remember, I talked about my dad being really upset when my 5th grade teacher talked about God to me, right? So the Supreme Court, this is long established. Parents have the right to choose their children's education. We see a lot of that kind of expression there. And so the Supreme Court said this is kind of privacy. And then we have some cases in the mid 20th century where people are being sterilized because they are criminal or mentally incapacitated or Black. And the Supreme Court says you can't do that. There is a right to procreation. There's a right to procreate. The framers really expected there to be some areas to be off limits to government interference. That's kind of why we have the 9th Amendment, but I think it just didn't occur to them. So the right to privacy is derived from the 4th Amendment. Remember, the right of the people to be secure in their persons, right? That means my body, right? I'm secure in it. The First Amendment, the right to peaceably assemble, to join with others that we choose to join with. And the 9th Amendment, which is, as I pointed out, something that says, hey, there's other rights out there. We just didn't list them all. And then that case precedent and tradition that I was talking about. The first case in this area to discuss sexual privacy was Griswold versus Connecticut, 1965. And the Supreme Court talks about a zone of privacy that cannot lawfully be denied. This is important. There are 2 places where this zone of privacy exists, according to Griswold versus Connecticut. 1, the marital bed. What we choose to do in our bedrooms is a zone of privacy. Or, you get the point. I mean, not in public, but you get the idea. And 2, any conversations and plans for treatment that are made between ourselves and our physicians. This is also a zone of privacy. That's really important. All those HIPAA regulations that we have now, they come from this case where it says, I cannot, if I'm given some privileged information, I can't share it with other people. My doctor cannot talk to my husband about my medical care unless I have signed a consent. I've done that because, I was going to tell him anyway. And most of the time, it's just easier, right? If they're going to leave a message. But you don't have to. You don't have to put your mother down or your father down or your husband or wife or whoever down. You have a right to privacy, and it cannot be denied. The most controversial case in this area is Roe versus Wade. It's decided in 1973. And the Supreme Court's going to decide that laws prohibiting abortion violate a woman's constitutional right to privacy, secure in my person, through the first trimester, because there are competing interests, right? And their big concern is right to privacy, right to life. They're competing concerns. So, first of all, you should understand that anytime the mother's life is in danger, she wins. There's no competition. It does not matter. If I am 8 months along and the doctor says you will die if you deliver this baby, then I have the right to choose what to do. That's what the Supreme Court is saying, right? Because we're talking about life versus life there, mother's life and unborn baby's life. But when it comes to that first trimester, the Supreme Court says that's not life yet. Many people, for religious reasons, will disagree with this. But what they use is a standard that is a medical standard. My father died 5 years ago. He was my best friend, and it was devastating for me. One of the most devastating things was he was hooked to machines, and the machines were keeping his heart going, just like a woman's body is going to keep the baby's heart going, okay? But even though his heart was going, at a certain point, the brain waves stopped. And at that point, he was no longer a human. He was no longer there. He was a human body. The Supreme Court's going to use the same reasoning when they talk about abortion. Until there are brain waves, that is a potential human, but that is not human life. There have been a number of other cases on abortion that have refined that, because they talk about first trimester in 1973. Medical science has advanced quite a bit. And so they know when they can determine brainwaves, have brainwaves happened. And if they are, right, then that's a different thing. But for the most part, they leave the second part, whenever there's no viability, right? That's the other issue. And that's how they could have decided it. Could the fetus live outside the mother's body on its own? Viability. Supreme Court said that's up to the states, right? That's up to the states. So if the life or health of the mother is endangered, self-defense wins no matter what, right? If Eric comes at me with a knife and I shoot him, self-defense. He's done it a couple of times, but
I know where you're at.
I've talked him down. Mostly. And thanks for your condolences. I appreciate that. Approval for Roe versus Wade. There's little public support for overturning Roe versus Wade. In 2016, 69% of Americans said, don't overturn it, right? That's a pretty recent and overwhelming majority, more than 2/3. There's also the question of homosexuality when we talk about the right to privacy. In Lawrence versus Texas, state criminal laws against homosexual acts were ruled to be unconstitutional. Going back to that Griswold idea, right? What you do as an adult sexually is your right. You guys, that's 18 years ago. 18 years. And so we're talking about recent changes in the law. Again, the 14th Amendment, I pointed out that due process clause was essential in incorporating all of these rights to the states. The equal protection of the laws is used in civil rights movement. Same-sex marriage, for example, Bishop versus US, which we will talk about later. That's more civil rights. Due process, civil liberties, equal protection, civil rights. Another key civil liberty, the right to vote and citizenship. If you look at this, basically it's only been 100 years since men and women over the age of 21 could vote. The 24th Amendment, which I think is interesting in the Florida case that we talked about, says there's no requirement. You cannot require that they have paid taxes or fees in order for a person to be able to vote. I think that's interesting when it comes to those fines in Florida. 26th Amendment, very recently, so we're only talking 50 years, all men and women over the age of 18 can vote. I talked to you a little bit earlier about how sometimes there's questions whenever it comes to our rights as an accused person when we're talking about war. War is often something, national security issues, we often curtail rights out of fear. As Benjamin Franklin said, those who would give up their liberties for security deserve neither, but we tend to do it. In World War II, we detained Japanese Americans in concentration camps. We've already talked about that in this class. We talked about the detention of enemy combatants, right? In both Hamdi versus Rumsfeld and Hamdan versus Rumsfeld, the Supreme Court said that there are basic rights of habeas corpus. But we also surveil people. The Patriot Act that was passed in the wake of 1113 included a lot of warrantless wiretapping. And, as much as we would like to believe, and I kind of saw some of this discussion over here, a lot of this that we, did I say 1113 instead of 9/11? It's possible. A lot of this, a lot of us would like to believe, absolutely, that those people who work for the government, who work in enforcement of law, are always the good guys. And I would hope that they believe that they're always good guys. But the question is do you have the right to listen in on my conversation because of something I said in a telephone call? Do you have the right to put a, wiretap on my phone, put something on my car? Over time, the Supreme Court has struck down bits of the Patriot Act over and over and over again. Which brings us to kind of those Snowden leaks. Now, he's still hanging out in Russia. But those wiki links about the NSA communication surveillance were interesting. We found out that the NSA had deals with all sorts of phone companies to tap into any of our phones at any time. Was that constitutional? No. So when we think about what we're willing to give up, and a lot of you, listen, you're going to say, and I get it, you're going to say, hey, look, if you don't do anything wrong, you're fine. But there's a lot of people who didn't do anything wrong, illegal, and are still in jail for it. Don't consent, okay, to searches. Shut up and call your lawyer if you're arrested. And recognize that there's something important here that the Constitution is trying to protect. It's trying to save the government itself from its bad authoritarian tendencies, because power is addictive. And so it's important that you stand up for your rights so that our government as a whole is a better place. You're being a good citizen by doing it. All right, that's it. Boomer.
Sooner.
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 Sooner.